Contracting with the U.S. government is incredibly lucrative. The government signs millions of contracts every year to buy a wide range of goods and services. To get these contracts, businesses engage in a highly competitive bidding process that involves working with a team to put together the most competitive offer they can manage in hopes of being awarded a contract. With that being said, for every contract awarded, there are usually multiple unsuccessful offerers who do not receive an award. For those unsuccessful offerers, the loss may be disappointing, but not surprising. And for others, the loss may come as a complete surprise, and they want to know what they can do to protest the award. For successful post-award protests, it is important for government contractors to know when to bring their protest attorney into the conversation and what legal and non-legal factors they should be considering when deciding whether or not to protest an award. Call your attorney immediately if you think you want to protest. I cannot stress this enough. One of the most heartbreaking things we experience is receiving a call from a CEO or owner explaining that their company lost an award due to an error by the government, but they call us too late to protest. The clock for protesting a contract award generally starts ticking the day the award is made, and it becomes a race against time to get that protest filed. Do yourself, your team, your attorney a favor and call your attorney as soon as possible after receiving the unsuccessful offer or notice. Additionally, involving your attorney early can actually help avoid the need to protest an award. Many procurements utilize enhanced debriefing, which allows contractors to submit written questions to the contracting office. In our experience, carefully crafted questions during enhanced debriefing can be used to highlight protestable legal issues with the procurement. Sometimes the government will take the opportunity to acknowledge and correct those errors without a protest being filed. So involving counsel early can ultimately be a cost savings for the company. Bottom line, involving your attorney early can be helpful to increase chances of success and give the company time to make that go, no-go decision on protesting. There are a lot of factors that go into a protest decision. Some are legal and some are business. Your parents told you that life isn't fair, and they were right. But when bidding on government contracts, the process should be fair, and the government must follow its own procedures. With that said, government personnel reviewing and awarding contracts are people, and people make mistakes and are not infallible. However, some errors are more problematic than others, and so we need to protest. When helping companies decide whether or not to protest an award, we look at what errors the government made and consider, 1, what type of error did the government make, as not all errors are the same. 2, if the government's error resulted in an award decision that it otherwise would not have made. For example, if the error is harmless, the GAO or Court of Federal Claims will dismiss your protest. 3, the cost of protesting and likelihood of award if the protest is successful. Not every protest results in an award. And 4, if the government's error is likely one that will be repeated on other contracts. Sometimes we see scenarios where the government personnel are engaging in bad behavior. If left unchecked, this bad behavior can take away opportunities for not only the most recent award, but future awards with that agency. So considering the value of the current award and future business with the agency needs to be part of your calculation when deciding to protest. Ultimately, to have the best chance of success, involve your attorney early in these discussions and decide if you need to protest.